Right, this is the third instalment on the topic dealing with exceptions to indefeasibility. It's quite a substantial topic, folks. And look, what we're going to mostly do in this final instalment, which will be a bit shorter, is to look at the register and the decision in Bursell and Berger Brothers, and then the other exceptions, most of which are found as statutory exceptions under the Torrens Act, the Land Title Act. But just before we do that, I just want to make a couple of observations continuing on from what I was saying in the last lecture. And just to return to the in personam exception, your casebook and in the slides there, I've documented that reference to what the authors of the casebook refer to as special equity cases, pages 499 through to 504. Special equity cases. Now, the idea of the in personam right is not just entirely necessarily a matter for equity. We can have personal rights against a registered proprietor that are grounded in common law. The rights, for example, of a purchaser in an uncompleted contract of sale is an illustration of that. But very typically they are equitable. And I just want to point out a couple of things with regard to these special equity cases. You can see those different types of situations where the right might arise, which equity would recognise and enforce against a registered proprietor despite the fact of registration. In the category of personal equity and breach of trust, that discussion at 5.113, starting on page 501, just see there that what's being looked at there is how the idea of this trust obligation arises and how it can be enforced against the registered proprietor. The High Court decision of Farrer Constructions and Say, which is a 2007 decision of the High Court, is important in that regard, in terms of this idea of trust and the fiduciary duty and what's required to fulfil that obligation. And this is basically pursuing the basis of a claim that was identified in that early 19th century English decision of Barnes and Addy, which basically tossed up different types of liability in a trust type situation, and it's referred to there, and you can see in the casebook the first limb talks about a recipient liability, and the second limb talks about an accessory liability. And the Farrer Constructions case is really looking at that second type of liability, that accessory liability from the Barnes and Addy classification. So just have a bit of a look at that. Look also at, a bit further down the page there's a reference to Macquarie Bank and 64 Throne, and just see how that's discussed as a Victorian decision, which also considering this type of an equity against a registered proprietor, just have an awareness of that. And then over on page 502, there's a reference to the Queensland decision of Tara Shire Council and Garner, which is a 2002 decision of the Queensland Court of Appeal. And you can see there the nature of discussion around the personal equity in the context of property on trust. So, and again, that's discussed in light of the decisions of Farrer Constructions and Macquarie Bank and 64 Throne. So just have a look at that discussion, and the discussion by Justice of Appeal Tadgell in the Macquarie Bank case, which there's an extract there provided for you in the casebook. Then you've got the other exceptions involving mistake, involving the unlawful action of public authorities, personal equity and easements. We'll see that easements also comes up in the context of statutory exception. Some of these are more relevant in some jurisdictions more than others. So again, when you're looking at the material, very important for you to, yes, get a broad sense of the general principle, but how is it relevant and applicable in Queensland, given the legislation we have in Queensland and given some of the case law that's applying the situation in Queensland. Remember, the casebook, of course, is written for all jurisdictions, as most of these books are. We're focusing on Queensland. You might be in another jurisdiction. Good, you can have a look at what's going on there, but the course you're studying is against the Queensland framework. So just always bear that in mind. Right, so we now finally move on to the register and call this the Bursell challenge and the registrar's powers of correction. So this involves, you can see in your casebook, 5.119C, case extract of Bursell Enterprises and the Berger Brothers, and then the powers of correction at 5.122, before we then move on to the other exceptions. So what's going on here in terms of the register and the Bursell Enterprises or the Berger Brothers case? Just before we talk a little bit about the Berger Brothers decision, the High Court, which is a 1971 case, we just need to remember that in the current period, there has been some developments. So the developments that have occurred recently, and I've already referred to these in classes, that in 3 jurisdictions, the register has become commercialised or privatised. Now, what is the implications of that? The implications are that the register is being managed by a private, commercial, for-profit entity, and that the government of the day has entered into a commercial relationship with that outside provider to manage the Torrens register. For a fee, of course, to generate funds for state revenue coffers. Normally, it's being undertaken in a sort of a long-term lease type scenario with regard to managing the register. In some way, it's being put together. The registrar or the land titles office in those jurisdictions where it's been implemented continue to have oversight, governance and responsibility, but the day-to-day management of the register has been outsourced. That's not the case in Queensland. So again, we're focusing on Queensland, not happening in Queensland, but that's a development that's taken place. And that is something to bear in mind when we think about the nature of the register and what's going on in Bursell. The whole point about this is that one of the fundamental principles of the Torrens system is the concept of the mirror principle. So that basically the register is a public register, and by examining the register, you will discover the matters that affect Torrens land as revealed on the register. Now, not everything is there on the register, but for those matters that can be recorded on the register, it reveals that information. You don't need to go behind the register, essentially, to discover things. So in the Bursell and Berger Brothers case, what we found was that there was an easement of way which encumbered the title to the property. And on the transfer, where this property was conveyed to an incoming purchaser, there was a reference to this easement of way, but the details were not there. So you basically, the essential point was that you had to actually go and look up the instrument, which was stored in the system, or in those days it was on a paper document, and you would need to examine its contents to understand the full nature of the interest that was noted merely by a number on the certificate of title, or on the document that was lodged with land titles. And one of the issues, like the central issue that arose was, well, is that something that you need to do? Do you need to go behind the, go and examine this other document to work out exactly the nature of the interests that you have, the quality of the interest, how it's affected by other things recorded on title, and so on? And what we found was that the case was a bit unusual as well, in the sense that it was about a strated an inner city building in Sydney, where it affected the strated nature of the building, and that's what this easement of way also related to. So that there was about this sort of horizontal stratum as part of the land which had been conveyed, and which was ultimately what the purchaser took as registered proprietor. And this, in a sense, predated the development of further regulation around that area of building practice, if you like, where we subsequently then had more developed laws introduced to govern that sort of spatial configuration of rights, if you like. But at the time when this case was decided, 1971, that wasn't as yet fully developed. And the point was that, well, if all of this information about what's affecting what was transferred isn't there on the face of the register, do we actually need to make further inquiries? And the point that Justice Windia in the High Court makes, and that's the judgment that you've been given the dissenting judgment of Menzies too, but Windia's in the majority, joined by Barwick, Chief Justice Barwick agreeing. He basically makes this point that Windia says that it seems to me that at the time from 1872 until today, that being the beginnings of when we understand these property rights rising in this situation, a prudent conveyancer acting for a purchaser of the land that is now Bursel's would have ascertained what it was that the numbered transfer referred to on the vendor's certificate of title in law effected. True, he might have been surprised to discover all that his research revealed, but surely no prudent person, seeing the reference to a right of way, would neglect to ascertain what exactly was the nature of the right of way, the land subject to it, the persons who could avail themselves of it, and what purposes and in what matter and at what times. He then goes on to say that, and it seems unlikely that a purchaser of this land in a built-up area in the city of Sydney would not be aware of the existence of the passageway and of the building above it. Whether he was so or not, the reference on the certificate of title to this transfer was, I think, constructive notice of what it provided. That is, the land was subject not only to a right of way, but also to an interest of the adjoining landowner in the building above the way. I think that the registered proprietor of the land that is now Bursel's held his title subject to that interest. So the point that we get out of the Bursell and Berger brothers case is in relation to what we need to appreciate to understand the nature of what actually the register is comprised of and what we need to examine to determine the array of potential interests or encumbrances that affect the registered title. So you can see, for example, in the questions posed in the casebook on page 507, the more enduring problem is that a purchaser cannot rely on a notification on the certificate of title to the legal effect of an instrument, but must assess the instrument itself. An instrument notified on the certificate forms part of the register, and it is the instrument which determines the legal effect. The question that's posed at the end of those questions is that, but are these obligations too onerous? Is it acceptable for us merely to rely on what's on the face of the register, as the mirror principle would actually suggest? So that's, you talk about the Bursell challenge, that's the challenge. And the other issue here, of course, is that today we have an electronic register and we have computerized folios of the register, and we've had that for a little while, okay? So that you will need to further investigate those matters that are recorded on title to find out the full nature and substance of what it is that is affecting title. In terms of any encumbrances or affectations, as we the terminology we use in property law to refer to such matters. And that's really the outcome that we get from the Bursell case. And it's interesting that the authors of the casebook note there on page 507, there would seem to be no reason why the approach in Bursell would not apply in jurisdictions other than New South Wales, even though there is variation in wording. And you can see there footnote 101 refers to the Queensland section, which is section 46. And I'm just going to show you that section. So you can see that this deals with the evidentiary effect of the CT. The certificate of title of a lot is conclusive evidence of the indefeasible title for the lot when it is issued. Now, in Queensland, it's no longer the practice to issue certificates of title as a matter of course. They can be requested, but of course we also operate within a computerised system now in terms of the documents, okay? So we need to appreciate that. You can see the matters accepted there and so on. But so the point being that, stop screen sharing that the Bursell case, even though it came out of New South Wales context, and as the authors of the casebook point out, we've got different wording, slightly different wording of relevant legislation in Queensland as opposed to New South Wales, and this point we've made before. There's no reason why that approach would not adhere in Queensland just as much as in somewhere else. And then the point comes that when you interpret the language of the section, is that, I mean, do you get that sense of it from what the court says in Bursell? And not really, but Bursell's case, qualifies that, and that's the challenge basically that we have before us. So one needs to just be aware of that dimension. That's the point that we need to make. And the added added complexity today is that we have a register that is now, in some jurisdictions, not Queensland, that's true, but there's movements in this direction, and Queensland may move in this direction, where we have a private for-profit entity managing the register. Now, when we come to the next topic, and part of that we will look at, when we look at unregistered interests, we'll also look at the assurance principle and compensation that's available where there are problems arise and the criteria for compensation are met. Well, how is that affected by this idea of commercialisation of the Torrens register? So that's for the next topic. All right, so let's just go back to slides. So we now move to the idea of the registrar's power to correct the register, and that takes us to section 15 of the Land Title Act. I'll just show you that. Again, the reason I'm doing this is because it's important to remember that the Torrens framework is a legislative framework. So, as has been emphasised in the case law, most recently in Cassegrain's case, which we've already seen in 2015, High Court decision, we must start with the legislation and we must start with the language of the Torrens Act that's relevant in our jurisdiction. For us, as I've emphasised, the Land Title Act. So we must keep always going back to the primary provisions that are relevant for our understanding and then proceed to the case law insofar as that's relevant. Where we've got this body of case law over a period of time coming from different jurisdictions, that's where the added challenge lies. We have to then ask to what extent does that body of case law apply for us in Queensland, given the wording of the provisions in the Land Title Act. So you can see there that we've got section 15 and, we're mostly, there's various dimensions of that section, but mostly we're just concerned with sub 1, paragraph A and B. The registrar may correct any register kept by the registrar if the registrar is satisfied that the register is incorrect and the correction will not prejudice the rights of the holder of an interest recorded in the register. Okay, and then the qualifications in the balance of the subsections of section 15. If you go to your casebook, you'll see that on page 508, again, at paragraph 5.124, the authors comment that the position in Queensland is in different terms to other jurisdictions. So, for example, the authors say that Queensland, the registrars also have a substantive power of correction, but in different terms. The registrar is empowered to correct the register if satisfied that the register is incorrect and that the correction will not prejudice the rights of the holder of a recorded interest, as we pointed out by looking at the wording of section 15. And there can also be, you will see, important to understand that there can also be the opportunity for the register, for a person that's seeking to have the register corrected. If the registrar says, no, well, I'm not going to act in this situation because I don't believe that the requirements of sub 1, for example, have been satisfied, then there can be an application made to the Supreme Court, Queensland Supreme Court, for an order under Section 187. So there's various, strategies that can be undertaken here to try and get the register corrected if it's felt that there's an issue there that needs to be addressed. The registrar has powers of correction, but there are other things that can be done if the registrar doesn't act. So be aware of that. So I'll just stop screen sharing that. We'll go back to the slides. Right, so that takes us then to the last part of this discussion on the exceptions to indefeasibility. It's been a bit of a journey, folks, but that's how I think it's important to, go into some of these matters in some degree of specificity, being specific about it. But it's also important to get what I call a helicopter view, and don't get lost in the detail. Okay, so to get a clear idea about the signposts in terms of what we're covering, what we want you to get a grasp of, but go into some of that detail and be aware of that detail, and also then have an understanding about how it needs to be applied, both in the context of disputes in regard to principle, and that arises, and you'll be tested on that in the context of problem-solving questions and assessments. But also, one of my aims here is to build a sense of practical and pragmatic understanding, and that's why I'm also giving you materials, for example, in relation to the Land Title Practice Manual. It's one of the reasons behind the initiative in regard to working with PEXA and the electronic conveyancing materials, and how that's being incorporated into assessments to build those practical skills and also an awareness around how we are now working in an electronic environment and how these ideas and principles need to work in that context today, which continues to evolve. And it's an important point, continues to evolve. And practitioners and those of us involved in property law in a practical sense, we don't spend all our days buried in the terse-nine principles that are coming out of appellate court decisions. There's a lot of practical application, a lot of documents that are processed and so forth in property law and land law. You've got to get a sense of that as well, in my opinion. Okay, so on to these remaining exceptions. I don't want to spend too long dwelling on these, except to point out in a practical way that, again, as I've indicated before, the casebook traverses the jurisdictions. So you're focusing on how these exceptions are reflected through the provisions in the Queensland legislation and any relevant discussion that's needed in terms of the case law. So that the first area looks at, as you can see there on page 509, is there an issue with regard to wrong description of the parcel of land or the boundaries? We looked at this back in Foundations of Property Law, LAWS 12065. Now, the case book, the authors are focusing a bit on the position in Victoria, but we're concerned about, as I said, Queensland, and we looked at that in the Term 1 course, so we won't really go back over that now. Just be aware of this idea of reservations and exceptions in the Crown grant, because all property derives from the Crowns, we know from our Term 1 studies, and even though we've now got a system of a land registration system under the Torrens system, the land itself originally came as a grant from the Crown, and you'll find that actually noted in the documents that are in the register. Tenancies, so that is discussed starting on page 510 at 5.129. this is really about the idea of how do we create an exception to protect certain unregistered leases. You can see there on page 510. Important to note that in Queensland, there's no distinction between short-term and long-term leases. So reference there to section 64 to 71 of the Land Title Act. In other jurisdictions, there is a distinction drawn between short-term and long-term leases. Okay, and when we talk about leases here, we're talking about general law leases. We're not talking about other specific type of leases that we'll have a bit of a look at when we get to that topic later in the unit. We'll also have a thorough look at the law governing general law leases as well. So the subsequent discussion really looks at the situation in other jurisdictions, and the perpetual trustee and Smith case really is covering situation in Victoria. So we won't dwell on that. So that's really all I wanted to say about that. Just be mindful of that. Be mindful of those specific provisions that exist in Queensland. In regard to easements, again, see there that we've really got two kinds of exceptions in the Torrens legislation, and you can see the authors refer to general and partial exceptions. Now, again, focusing on Queensland, about halfway down that first paragraph, the paragraph numbered 5.141. In Queensland, under section 1851C, I'm just going to pull that up for you. So again, this is the exceptions to indefeasibility provision in the Land Title Act 185. So we can see there that 1851C, the registered proprietor of a lot does not obtain the benefit of section 184 for the following interests in relation to the lot: the interest of a person entitled to the benefit of an easement if its particulars have been omitted from or misdescribed in the Freehold Land Register. So this exception is focused on where the easement or its particulars have been omitted or misdescribed. In other jurisdictions, the nature of the exception is wider and differently comprised, but that's the focus in Queensland. So that we need to bear that in mind. We also have the situation of adverse possession. Now, this came up in, again, the Term 1 unit, and you will see that so just returning to that legislation, we can see that 1851D deals with the interest of a person who on application would be entitled to be registered as owner of the lot because the person is an adverse possessor. Now, we saw in the Term 1 course that that can mature into a capability to have the interest registered. And if we just come back to section 99, which is referred to in your casebook at 5.147, it's under section 99 that that person can then apply to the registrar to become the registered owner. Okay, so again, they're the significant features of the Queensland situation. And you'll see there's a reference to rates and taxes. So just be aware of that possible exception. Overriding statutes. Now, overriding statutes are interesting. You might say, why are they so interesting, Mike? They're interesting because they give rise to this potential conflict between the fact that the Torrens system is giving indefeasibility of title to the registered proprietor and those other interests that can have the quality of indefeasibility. But of course, the normal arrangement is that where we have legislation passed in a whole range of areas, obviously, within a jurisdiction, I'm not talking here about Commonwealth legislation overriding state legislation for purposes of inconsistency, but where you've got state-based legislation and subsequent legislation inconsistent with earlier legislation, in this case the Land Title Act, for example, then the normal assumption is that to the extent of inconsistency, that it impliedly repeals that earlier enactment. Well, this raises a concern in the context of what the registered proprietor has under the Land Title Act, the Torrens Act, if that operates with full effect. And what you'll find discussed in, starting on page 523 at 5.151, is, well, how have the courts tackled this in terms of thinking about overriding legislation? Okay, and as is noted in a New South Wales decision of Quach and Marrickville Council in 1990, Justice Young observed that overriding statutes represent the weakest point in the Torrens system. And that may well be so. But what we find is that the courts have tended to adopt what's referred to over at paragraph 5.156 as a sequential approach, which entails reading the provisions of later statutes in a restrictive manner so as to avoid abrogating the indefeasibility provisions. So this so-called sequential approach, which has been applied in a case law, so you'll see reference to City of Canada Bay and City of Canada Bay City Council and Bonacorso, which is a New South Wales decision, 2007, and then the High Court decision in Kumpatu Local Aboriginal Land Council and KLALC Property and Investment, which is 2008. Again, sorry, it's a 2008 New South Wales decision, dealing with these ideas of this sequential approach to interpreting legislation. So basically what's happening is we're putting restriction on how we view the later enactment so that it doesn't fully abrogate the indefeasibility that's provided for under the Torrens Act, in this case, in our context, the Land Title Act. You can have a look at another approach that's been adopted in the Hill Palm and Heaven's Door High Court decision, which is a 2004 case. You see the authors of the casebook there at 5.157 say, another way in which a later statute may be restrictively construed to avoid modifying the indefeasibility provisions is to interpret it as creating rights that operate only in personam and do not run with the land. So there's another way of trying to accommodate the fact that later enactments, where inconsistent with earlier enactments, will impliedly repeal an earlier enactment. How that's to be effected in the context that we can't really allow later enactments to totally abrogate the indefeasibility that a registered proprietor acquires by as a consequence of compliance with the provisions of the Torrens Act. So just have a look at that discussion and just have a think about that in the context of, well, what balance should be struck here with regard to this tension, and where you know, what approach is preferable to try and strike the right balance. That's really what the courts are trying to do here. And it's a fair point that to say that this is to some degree challenging in trying to work out how we get that balance right. But it's something that we need to try and do, because we just can't allow, as I indicated, for that indefeasibility under the Land Title Act in our case to be completely effectively impliedly repealed by later enactments. That's not possible. Otherwise, it'll basically the consequence will be that the rationale of the system will be to naught. We can't. It's not practical, and we can't have that. And then we're just also just being aware, just lastly, that there is some discussion of statutory charges and how they function. And you can see there a reference in Queensland to section 29 and also to section 34. You can have a look at those sections dealing with how statutory charges function in terms of these other exceptions. Right, so that finally brings us to the end of this topic on exceptions to indefeasibility. So I know this has been a bit of a journey, folks. We've had 3 lectures on this, but it is a fairly substantial topic with a substantial body of case law, legislative provisions, some challenges there in terms of what we need to get our heads around. But what we've focused on in this last lecture on this topic is to those last special type of equities in terms of the in personam exception, or the personal rights exception, put it like that, to also reflect upon the register, the nature of the register. Think about that in the modern period with changes that are taking place in terms of commercialisation and privatisation. Be aware of the registrar's powers of correction under the Land Title Act and the nature of the particular provisions in Queensland under the LTA. And then lastly, to appreciate, to give thought to the other recognised exceptions to indefeasibility of title that are also there and reflected through the legislative arrangement. So there we are, folks. That's exceptions to indefeasibility of title. Our next topic will be also somewhat challenging, but we'll march on to it, and where we will look at unregistered interests and also compensation for loss reflecting the assurance principle. So until then, bye for now.